Nnamdi Kanu is fighting to overturn his life sentence with 22 separate legal arguments. But here's what almost nobody is talking about. While he fights to bring his sentence down, the Nigerian government is simultaneously fighting to take it up, all the way to death. Two appeals, same case, completely opposite goals. And IPOB says the government's own filing may have just handed Kanu's legal team the strongest weapon they've had in a decade-long fight. So which appeal actually wins? By the end of this video, you'll understand exactly what's at stake for Kanu and for how Nigeria's justice system handles political dissent. Before we go any further, if you are new to this channel, welcome. Naija Insight Desk exists for one reason: to give you the kind of analysis that goes beyond the headlines and the noise. Subscribe now, because this conversation is about to get deeper. On November 20th, 2025, Justice James Omotosho of the Federal High Court in Abuja convicted Nnamdi Kanu on all 7 terrorism-related counts brought against him by the federal government, following a trial that stretched back over a decade. He was sentenced to life imprisonment on 4 of those counts, with additional concurrent sentences of 20 years and 5 years on the others. The judge held that Kanu's broadcasts and directives to IPOB incited deadly attacks and found that Kanu offered no credible defense, a decision Kanu's lawyer, Aloy Ejimakor, immediately vowed to appeal. That appeal came on February 4, 2026, when Kanu's team filed a formal notice with 22 separate grounds, asking the Court of Appeal to quash both the conviction and every sentence attached to it. The central argument that the life sentence was imposed without allocutus, the defendant's constitutional right to address the court before sentencing. Other grounds include claims that a trial relied on a repealed law, that a disrupted 2017 trial was never properly resolved, and that his years abroad were wrongly treated as evidence against him. But this story took an unexpected turn. Around a month before this recording, the federal government filed its own cross-appeal, not to defend the life sentence, but to challenge it as too lenient, arguing the trial court should have imposed the death penalty instead. Let's break down exactly what's now before the Court of Appeal in Abuja, because there are 2 separate competing filings. Kanu's appeal asks the court to find that the trial court made procedural errors serious enough to void the entire conviction, not just reduce the sentence, but overturn it completely. The federal government's cross-appeal makes a striking legal claim of its own, that the trial court actually lacked jurisdiction when it imposed life imprisonment on several of the counts. The government isn't arguing the trial was flawed, it's arguing the sentencing itself was procedurally improper and that the correct penalty under the Terrorism Prevention Act should have been death. Here's where it gets legally complicated, and this is worth sitting with. IPOB's response, through spokesperson Emma Powerful, argues that the government has effectively contradicted itself. If the trial court truly lacked jurisdiction to impose life imprisonment, as the government's own filing claims, then, under Nigerian law, jurisdiction isn't something that can be split between conviction and sentencing. IPOB is arguing that admission means the entire sentencing exercise could be void, not just the length of the sentence, but the government's own path to seeking a harsher one. To be clear, this is IPOB and Kanu's camp's legal interpretation of the government's filing, not a ruling by any court. The Court of Appeal has not yet weighed in on either the jurisdictional question or the merits of either appeal. What we can say factually is that the government's cross-appeal exists, that it does seek the death penalty, and that it's now sitting in the same appellate process as Kanu's own 22 grounds. Why would the federal government risk this now? One read: deterrence. A death penalty push signals maximum severity towards separatist agitation at a moment when Southeast security concerns remain politically sensitive heading into 2027. Lawyer Aloy Ejimakor has offered a sharper interpretation that the cross-appeal is designed to pressure Kanu into publicly renouncing the Biafra movement, using the threat of execution as leverage. IPOB has flatly rejected that framing and vowed Kanu won't be moved by it. But this move carries real political risk for the government too. Kanu holds dual Nigerian and British citizenship. Ejimakor has warned that pursuing a death penalty against a British citizen could trigger a genuine diplomatic crisis with the United Kingdom. International law and diplomatic norms around executing dual nationals are a minefield the Nigerian government would be wading into with eyes open. There's also a domestic political layer. A group of 44 members of the Nigerian House of Representatives has formally urged President Tinubu to pursue a political resolution rather than continued judicial confrontation, a sign that even within the ruling coalition, there isn't unanimous appetite for pushing this fight to its harshest possible outcome. Abia State Governor Alex Otti has gone further, telling reporters after a meeting with Tinubu that he believes Kanu will regain his freedom in the not-distant future, a striking statement given the government's own cross-appeal is simultaneously seeking the opposite outcome. Who benefits from prolonging this fight? Frankly, almost no one politically. Not the government, which risks international backlash, not the Southeast political class, which faces growing youth agitation over Kanu's continued detention. That contradiction, hardline legal posture alongside quiet political signals towards resolution, is one of the most interesting tensions in this entire story. Now, if what you just heard challenged what you thought you knew, drop it in the comments. I want to hear your read on this before we get to the part that reframes everything.
Beyond Kanu himself, this case is testing something bigger: how Nigeria's justice system handles the line between prosecuting violence and prosecuting political speech. For federal-state relations, Southeast governors and traditional rulers have grown increasingly vocal. At a February 2026 Traditional Leaders Summit, a monarch directly told President Tinubu that Kanu's continued detention was fueling youth agitation and eroding traditional rulers' credibility in their own communities, a signal that this case is shaping grassroots political trust well beyond the courtroom. For security, how this resolves will shape whether Southeast agitation escalates or cools. A death sentence pursued against Kanu risks becoming a rallying point rather than a deterrent. History in Nigeria's Southeast suggests martyrdom narratives can strengthen separatist sentiment rather than weaken it. For ordinary Nigerians watching this unfold, this case has become a proxy for a much larger question: whether Nigeria's courts can be trusted to handle politically explosive cases on procedure and law alone, insulated from the political pressures surrounding them. For the diaspora, particularly in the UK, where Kanu holds citizenship, this is no longer just a Nigerian domestic story. Ejimakor's warning about a UK diplomatic crisis isn't hypothetical noise. Nations generally take extreme diplomatic exception to the prospect of their citizens facing execution abroad, and Britain has historically been assertive on this front with other countries. If the Court of Appeal takes the government's cross-appeal seriously, expect UK government statements, possible consular pressure, and renewed attention from international human rights bodies. The UN Working Group on Arbitrary Detention has already weighed in on Kanu's case once before, concluding his original 2021 rendition from Kenya was unlawful. This also feeds into a broader continental conversation about how African governments handle separatist and secessionist movements through the courts rather than through political negotiation, a pattern diaspora communities have watched play out in multiple countries across the continent, with mixed and often destabilizing results. Let's steelman the government position before we push back on it. The strongest version of their argument: Kanu was convicted on all 7 counts after a trial that ran for over a decade, with a judge who explicitly found the prosecution proved incitement leading to real, deadly violence. If the applicable law prescribes the death penalty for these offenses and the trial court had discretion to impose a lesser sentence, the government pursuing the maximum lawful penalty is, on its face, simply enforcing the law as written, not persecution. The most common misconception online right now is that IPOB's "the sentencing is void" argument means Kanu is about to walk free. He isn't, not automatically and not soon. That's IPOB's legal interpretation of the government's filing. It's not a ruling, and the Court of Appeal hasn't scheduled a hearing on either appeal as of this recording. Treating this as a done deal in either direction, release or execution, is premature and inaccurate. What nuance gets lost in the noise? That Kanu's own appeal and the government's cross-appeal are, procedurally, opposite arguments that could theoretically both fail, both succeed in part, or produce a genuinely strange outcome where jurisdictional technicalities void a sentence without resolving guilt. This is messier and more uncertain than either side's public statements suggest. 3 things to watch in the coming weeks and months. First, whether the Court of Appeal schedules a joint hearing on both Kanu's 22-ground appeal and the government's cross-appeal, or handles them separately. That alone will signal how the court intends to approach the jurisdictional argument IPOB has raised. Second, watch for any formal UK government response or statement. If London engages diplomatically on the death penalty cross-appeal, that changes the entire international pressure calculus on this case. Third, watch the political track running parallel to the legal one. Governor Otti's comments about Tinubu being favorably disposed to a resolution suggest back-channel negotiations may be happening independent of the court process. If a political resolution emerges before the Court of Appeal rules on either filing, the entire legal fight could become moot. This escalates if the Court of Appeal engages seriously with the government's death penalty request and the UK responds with diplomatic pressure, a scenario that would make this one of the most internationally watched legal cases in Nigeria's recent history. It de-escalates if a political settlement of the kind Otti has hinted at resolves the matter before the appellate court rules on either filing. So which appeal actually wins? Based on everything we've laid out, the honest answer is it's genuinely too early to say, and anyone telling you with certainty that Kanu will be freed or that he faces execution is overselling what we actually know right now. What we do know is that Nigeria's courts are now being asked to resolve 2 contradictory outcomes from the same case using the same set of facts, and how they do that will say as much about Nigeria's institutions as it does about Kanu himself. We're leaving one thread open deliberately. What happens when the Court of Appeal finally schedules a hearing date? That's the moment this story moves from filings and statements to an actual legal decision, and that's the video we'll bring you next. If this analysis gave you clarity, not agreement, clarity, share it with one person who needs to understand what is actually happening. Like, subscribe, and I will see you in the next one.